Good afternoon to all participants. I would like to thank you for joining us today at a webinar jointly organized by the International Arbitration and Mediation Center, Hyderabad, and AIADR. Before we start with the discussion, I would like some introductory remarks from the representative here from AIADR. Sir, you may please go on.
Excellency, esteemed panelists, distinguished guests, ladies and gentlemen, greetings from Hong Kong and welcome to the webinar on institutionalizing mediation. How does it affect parties, lawyers, representing parties and the institutions, and Indian perspective? It's my great privilege and honor to deliver the welcome address for this webinar. As the Council Member, Director, Honorary Secretary of the Asian Institute of Alternative Dispute Resolution, AIADR. As we all know, the movement towards institutionalizing mediation through court-connected programs and those alike has raised many questions, as it has become increasingly common in the recent years. Mediation has captured the interest of lawyers and judges, and we see a growth spurt in court-sponsored mediation programs. In Hong Kong, the development of mediation is no longer in its infancy. Almost 5 decades after incorporating the process into the labor dispute resolution system, it is now applicable in other specific fields and considered suitable for most types of contentious cases. In the words of Mr. Joseph Rippon, an ounce of mediation is worth a pound of arbitration and a ton of litigation. Today, as we unpack the implementation and effectiveness of institutionalizing mediation, I hope you take away key points, identifying the major benefits and weaknesses of the development of institutional mediation. I'm sure with the expertise of the panelists and the discussion by the panel, the participants would gain a deeper insight on the subject matter. I would also like to take this chance to welcome Ms. Sanayana Kandana, the moderator of the section, and the esteemed panelists, Ms. Chindra Narayan, Ms. Purnima Singh Campbell, and Mr. Ramakant Vande to this webinar. I hope that by the end of this webinar, the participants would gain a different perspective on the recent developments and expand their vision and understanding of the mediation mechanisms. Once again, I express my utmost gratitude to all participants who are present today. Thank you so much for your very kind support and time. I wish this webinar an enlightening section and a great success ahead. Thank you so much. Thank you.
Thank you so much, sir. Thank you so much for your remarks. We may now start the session. I am Sunena Kandala, and I'm currently working as an associate counsel at the International Arbitration and Mediation Center, Hyderabad, and I will be the moderator of the panel today. This discussion today is dedicated to the language of mediation, its essence, and the entire spirit of the process. And to start the discussion, I would first like to introduce you to our esteemed panelists. We are truly fortunate to have with us today our three very senior members of the mediation and arbitration community from India. I'll start introducing Ms. Chitra Narayan. Ms. Chitra Narayan is a lawyer and an accredited mediator with experience mediating commercial, corporate, and family disputes. She's a professor of the practice with the Daksha Fellowship at Sai University, Chennai. She's worked in corporate commercial law, both in transaction advisory and dispute resolution, which she brings to support her work in arbitration, mediation, and conciliation. She's an accredited mediator with the Tamil Nadu Mediation and Conciliation Center, a founding trustee of Foundation for Comprehensive Dispute Resolution, Chennai, a mediator at the Compliance Advisory Ombudsman of the World Bank Group, and with the Global Mediation Panel for UN agencies. Ms. Narayan was one of the mediators appointed by the Mediation and Conciliation Project Committee of the Supreme Court of India in 2020 to draft a legislation on mediation for India. Our next speaker, Mr. Ramakant Reddy. Ramakant Reddy, sir, has been practicing for more than 30 years in constitutional, civil laws, criminal laws, and consumer disputes. He started from trial court and continued there for 10 years, following which he practiced in all other high courts and Supreme Courts. Presently practicing in Honorable Supreme Court, wherein he won prestigious cases for the statutory bodies he represented, and as regards individuals, he argued the case of Mohammad Azharuddin, former Indian cricket captain, in his life ban case, and the Honorable High Court Division Bench at Hyderabad declared the life ban imposed on him as illegal, arbitrary, and set aside the same. He is also an internationally accredited civil commercial mediator. The third speaker for today is Ms. Purnima Singh Kamble. With more than 23 years of experience handling a range of legal issues for diverse industry sectors, Ms. Purnima has gained a reputation for understanding the pulse of her clients and consistently delivering optimal solutions. As a partner at Fox Mandal's Hyderabad office, she primarily focuses on corporate, commercial, and real estate practice. Ms. Purnima oversees the firm's Hyderabad operations with additional focus on the pan-India corporate real estate practice. Ms. Purnima is also an accredited civil and commercial mediator. Thank you to all the panelists who are here today. Our theme for today's discussion is institutionalizing mediation with an Indian perspective. Institutionalizing mediation will allow mediation in far more diverse sectors. Institutions can identify mediators with the right technical background and expertise. Trust in such institutions developed over the years will also enhance the legitimacy of choosing mediation in such niche sectors. Following which Ms. Chitra Narayan will begin the session while sharing her insights on the mediation fundamentals and process, how the current landscape of mediation prevails in India. Ma'am will also throw some light on the need for institutions providing services like mediation and their advantages. Following that, Mr. Ramakant Reddy will cover the role of lawyers assisting the parties to mediation and to what extent is their assistance required. Sir will also share his views on the working of court-annexed mediations in India, with also sharing his views on institutions and mediation. We will then have Ms. Purnima Kamble wrapping up session with her suggestions to parties opting for mediation, how and when to approach mediation, what they should expect from a mediator, and some challenges that professional mediators share with regards to parties in the mediation process. So each panel member here will elaborate for 15 minutes, and I'm delighted that we have such an esteemed panel. So please take the opportunity to drop us a question, and we will try to address them during the question and answer session in the last 10 minutes of the webinar. So without further ado, Chitra ma'am, perhaps you can walk us through the fundamentals of mediation and the process.
Thank you, Sunena. Thank you to IAMC and AIADR for having this session, which is very important, and for inviting me to speak here. I will start with describing the process of mediation. That is something that is probably familiar to you, but I think the an understanding or a description of the process, its reinforcement is extremely important. Mediation is defined as a process where parties who have a dispute or a conflict sit together to discuss the issues relating to the conflict with a view to settle these issues. They are assisted by a third person, a neutral third person, and this person is called a mediator. The mediator will support the parties, facilitate discussions, and assist the parties in their discussions to resolve the dispute. But the mediator does not have the authority to, unlike an arbitrator, to impose a decision or to tell them how they must settle their dispute. Now, it seems like a very underwhelming definition because it doesn't, or ephemeral in the sense that we talk, we settle. I mean, is that it? No, but mediation is a very structured process. There is a lot in mediation. There is a lot that weighs on the parties, because it is the parties who decide if they are going to settle their dispute and how they are going to settle the dispute. What is the role of a mediator here, and why do you need a mediator? Can't parties negotiate amongst themselves and resolve their dispute? There are some definite advantages to having a mediator and following the process of mediation. To start with, the role of the mediators is, begins with the very important task of even getting the parties together to a table or to a room. When there are conflicts, when there are disputes, parties have persons who are in dispute have their backs up. They're angry, they're troubled, they're upset, and they don't want to talk with the other person or the other persons in the dispute. And to tell them, to expect them rather to speak with the other persons and say, let us resolve this dispute. That can be an expectation, but does it happen often? No, it will not, because they are upset. Right? And the mediator then has a very important role of actually bringing the parties together to start talking. It is the mediator who takes the effort of explaining what the mediation process is, telling them that this might be worthwhile for you to attempt. Institutions like the IAMC then play a very important role, because I'm sorry, I think.
Yes, ma'am. I think there was a small disturbance. Yes, ma'am. You may continue.
Yeah, my apologies. So institutions like IAMC will have a panel of mediators with different skill sets, different experience levels, experience. What the mediator does is follow a very structured process of mediation. The mediator has what is called an opening session with the parties, where the mediator introduces themselves. There could be one, there could be two, there could be three mediators, and that depends on the nature of the dispute, the complexity of the dispute. The mediator explains the mediation process to the parties, and there are certain aspects to mediation that are very integral to mediation. The first is that it is a voluntary process, and so parties must be willing to participate and to try out the mediation process. The second is that discussions in the mediation, particularly concessions made, admissions made, proposals, willingness to accept a proposal. These are all discussions in the mediation, which are confidential, which remains in the room, and it encourages parties to speak more openly about what the issues were, to speak frankly and very freely without, worrying about where this conversation is going to go out. So that's the second part of mediation. The third is that the mediator sets the ground rules about parties discussing the issues together, as well as parties discussing issues separately with the mediator should any of the parties want it or should the mediator want it. Right? So there are joint sessions and there are private sessions, and all of this is explained by the mediator to the parties. Parties are free to set a time limit for this mediation. They can say that, look, we will try mediation, but probably we will not give this more than 30 days. Parties are also free if they find even within this 30 days that the mediation process isn't helping them much, or they are anxious about initiating proceedings in arbitration or in the court. Parties are free to terminate the mediation. So that's where the element of voluntariness comes in this process. The mediator then asks the parties to talk about what the problem was, how the dispute arose, what the issues are between the parties, and they all listen to each other. And typically, this is done in a joint session, not necessarily so, but typically, because then everyone listens to the other's perspective of the dispute. Right? So you hear from persons with whom you're antagonistic about how they thought the dispute arose, what they felt went wrong, where they felt hurt or wronged, And to listen to this, you initially have your backup, but when you listen, you start, loosening because you're hearing other perspectives to what happened or how the dispute arose. The mediation process allows for expression of emotions by the parties. If I'm angry, I am hurt. A typical arbitration or a court process doesn't allow for, these kind of, an expression of emotion or anger or, hurt. But mediation allows for it because this is important. Emotions are a part of disputes, are a part of conflicts, and the mediation then allows parties an expression of such emotion. The parties in the first stage, after understanding what the mediation process is, will talk about the history, how the dispute arose and why they are where they are. The mediator allows for more detailed discussions of the dispute, more detailed exchange of information, if necessary, documents to be shared and shown, and then moves the parties from discussing about the past to, yes, now we're here, we're going to work together to resolve this. What do you want? How do you think we can resolve this dispute? What are the issues that you think need to be resolved in this mediation? This then moves to parties, setting an agenda of what are the issues that the parties would want to discuss, and thereafter moving forward to how the parties think, what are the expectations in a settlement, how the parties think they will want to resolve the dispute. And these options are discussed among parties until they come to, what is called a zone of possible settlement. Where is there an overlap between the parties on how a settlement can be arrived at? And once that is arrived at and the parties, they finesse it, they improve on it, they tighten it, they make it narrower, and then you have an agreement which the parties then sign. And this is the settlement agreement, and this is how the disputes are resolved. There are issues as we go along because parties could, be repetitive about the same thing. There could be a stalemate because one person is simply not agreeing to what the other person has proposed. The mediator employs techniques like reality testing, like evaluating together with the parties. Right? That is by asking open-ended questions to the parties about, what are the strengths of their case, what are the problems of their case, what do they think will happen if they were to take this dispute, not settle here and take this dispute to arbitration or to take it to court, in terms of time, in terms of costs, in terms of the strength of their case. And this helps parties to reconsider how they are approaching the settlement, and hopefully will lead to a settlement. I have seen these transformations take place. I have even seen in groups of persons who had a claim against, a fixed sum of money from the arrest and sale of the ship. how there were party creditors who were not that well off, who had supplied food to the ship and who had smaller claims, and you had companies who had bigger claims, and these companies said, look, I'll give up some of my claims, because if I gave up 10 or 20,000 out of the few lakhs that is my claim, it's going to matter a lot to the smaller creditor. So it's a very healing and a transformative process. So this then is the mediation process. Let me move to the landscape in India. We hear people speak of mediation being used from time immemorial, and there are anecdotal sort of instances of it. There are also efforts at mediation without, in the community, amongst the fishing communities in the state that I come from, Tamil Nadu, there is use of mediation as well. There is use of mediation amongst many, many communities who resolve disputes with the help of a third person assisting them in resolving it. The formal or institutional level mediation in India began with the Industrial Disputes Act, and in fact, a little prior to that, under the Government of India Act, for resolving labor disputes. So like Mr. Mansingh was talking about Hong Kong starting mediation or conciliation with labor disputes, that is the case in India as well. In 1999, we had an amendment to our Code of Civil Procedure, which sets out the processes in civil cases in civil courts. And there was an introduction of Section 89 in this code, which said that the courts in a civil case, if the judges, if they felt that there was a possibility of settlement, the court could refer the parties to mediation. This led to the Supreme Court of India taking very active steps through a judgment called the Salem Bar Association judgment in 2005, with the direction to set up court-annexed mediation centers. We have the Mediation and Conciliation Project Committee of the Supreme Court, which is a program that has been set up specifically to implement mediation. We have court-annexed mediations centers throughout the country. All the high courts, the lower courts, the labor courts, family courts, all have court-annexed mediation centers. And I think Mr. Ramakant Reddy is going to tell us a little more about it. The second if I could say, sector-agnostic effort at mediation was under the Arbitration and Conciliation Act of 1996, where Part 3 of this law talks about conciliation. Here, the conciliator is given additional responsibilities, where the conciliator will also propose to the parties, after listening to them, looking at their documents, a way to settle their disputes. A draft settlement would be proposed by the conciliator. The parties are free to accept it, modify it, or completely reject it. There are provisions that safeguard confidentiality, the right of parties to proceed, take proceedings before the court if they need some urgent interim reliefs while the conciliation is on. So mediation and conciliation in terms of sector-agnostic policies have gone in these two tracks: conciliation under Part 3 of the Arbitration and Conciliation Act, and mediation through court-annexed mediation centers. I, as have I think many others, we are lawyers who have been trained as mediators by these courts. We work as a part of the court-annexed mediation centers. There have been several regulations and laws that have adopted mediation as a part of a dispute resolution continuum. There are about 20-odd legislations that speak of mediation. This is, the landscape. And most recently, we have had the government introduce a mediation bill before one of the houses of parliament. This is pending before them, and this is intended to be a sort of an umbrella policy on mediation. And I think a very important aspect in this bill, that's relevant for our conversations today, is the fact that it emphasizes institutional mediation, makes provisions for the recognition, the setting up of mediation service providers, as well as mediation institutions, which will train mediators. And we look forward to having a large resource base of mediators who help parties resolve conflicts themselves. Mediation, as you might have realized by now, is a very empowering process. And through this, we will have, in the not too distant future, disputants deciding how their disputes will be resolved by themselves. Thank you, Sunaina.
Thank you so much, ma'am, for sharing your insights. That was quite enriching, crisp and clear, the fundamentals, the process of mediation. And the takeaways that I would have from what you would share is how the process is healing, transformative, and empowering. So these are my takeaways. They are very, very strong words. And I think that's very, very enriching, ma'am. Thank you so much. Mr. Ramakant Reddy would now elaborate the role of lawyers in the mediation process. Sir, the floor is all yours.
Good afternoon, everybody. Thank you, ADR and IAMC, for giving me this opportunity, and everyone for joining us. I would be speaking on the role of lawyers representing assisting parties in mediation. Now, as you all know, mediation itself is a kind of needs lot of awareness among the general public, the citizens of India. Now, slowly it's gaining some, it's being noticed in our country, and thanks to International Arbitration and Mediation Center, Hyderabad. Thanks to you all, Purnima, Chitra, Sunaina, because you are all, you have been there since long and, striving hard to ensure that the justice system is accessible. The load on the judiciary has come down mainly because of, great services by lawyers and, mediators without legal background as well. And thanks to Tahir Saab, who is going all out to spread this mediation and this concept, and also spread this concept that lawyers are not, there is no threat to the lawyers with the entry of mediation, because most of the lawyers feel that mediation means it's a threat. No, lawyers also have a huge responsibility. Lawyers have a huge role, not only in helping parties, litigants resolve disputes, but also taking this concept of mediation, which is ancient, into the general public, because many of our people who are entangled in litigation are not aware of mediation, and not at all about the role of lawyers in mediation. Not just parties, even the lawyers are not aware of their role, the contribution they can make in resolving a dispute. So this message has to be taken from the district court level onwards into the lawyers and as well as the masses. Now ADR, like we have been discussing, is coming in a big way, and lawyers who are also mediators have a huge responsibility and a big role to play. Now, how do lawyers come into picture? How far lawyers will be helpful is the question. Now, generally, when it comes to a given dispute, which is pending in the court or not, when there is a dispute, there is a litigation. That litigation lands in a court or where people are aware. For example, we take European Union states or countries where, like Hawaii, California, Norway, or places like that. Mediation is mandatory before they are allowed to step into any court. But here it is not like that. So here the lawyers who are, clients have confidence in their lawyers. Now it's the lawyer who has to suggest that there is a way out of this litigation. It is cost effective, it is quick, and these are the possibilities. A lawyer's role is very important because lawyer knows the law, lawyer knows the dispute and the lawyer knows the consequences. And the client, if he's explained about all these aspects, then the dispute resolution becomes easy. Now, dispute resolution will, lawyers' role in dispute resolution can be there from right from the beginning onwards or at any stage. So it is not restricted to any one stage. And once lawyer takes up the role of assisting, he should be guided by principles and not by rules and regulations. If he is guided by rules, then he won't be able to do justice. Lawyer has to be guided by principles. Lawyer has to be guided by only principles. Whereas in adversarial system, judges give a judgment. But here, when it comes to mediation, it is entirely different. Now, a dispute is resolved or not, if the role of lawyer, when a lawyer assists parties, at least it narrows down. And resolution, when lawyer is assisting any person who is in the process of getting out of the litigation, then it becomes very easy. So my experience as a mediator is the main advantage of having a lawyer is the lawyer can understand the problem with his knowledge of law, and he can advise the client in the best way, and a lawyer will be more effective, will be of more effective assistance to a person in who is a party to any dispute rather than a layman. Now, when it comes to court annexed mediation, I would like to share my experiences on that. In many parts of the country, there are not so many facilities to courts annexed mediation. But wherever there is court annexed mediation, the results have been very high. And recently it's been, the studies have revealed that it's about 86%. And in the court annexed mediation, generally, when it comes to Hyderabad or any other place, the registrar is the person who runs the office of the mediators, and he himself is the mediator, or there are other trained mediators who cater to the needs that are necessary. And essentially, they are part of the judicial system. And normally, there is a waiting period in Hyderabad because of the awareness that has started now. There is a waiting period for accommodating the parties. And in urgent matters, they are given special dates. And it's going on in a very positive manner. So that is my experience on this role of lawyers. I would say it's very important, and it's proving to be very effective. And it's driving the clients towards resolution quickly. Thank you.
Thank you, sir. Thank you so much for your remarks. Like you had said, the clients have confidence in their lawyers. So it's the duty in some way of the lawyers to create more awareness, and maybe that's the challenges even as a center we face when parties come to us for mediation. There's some kind of hesitance to even knowing what the process is like. So the lawyers should encourage their clients to go for mediation for their disputes, and like you rightly pointed out, they can give an effective solution to it. the lawyers can guide the clients. Thank you so much, sir, for your remarks. We would now move on to our third speaker for the day, Ms. Purnima Kamde, who will enlighten us with her views and suggestions for parties involved in the mediation process. Ma'am, the floor is yours.
Thank you. Thank you, ADR, and thank you, Tariq and Sunaina and IAMC for giving me this opportunity. It's a pleasure to be speaking with such a, highly accomplished panel that we have now. Chitra has very rightly covered the entire spectrum of what is mediation, and looking at mediation from an Indian context. And Ramakant sir has very well outlined the role of lawyers, in the whole sort of process of mediation. What I'm going to talk about now is where are we going wrong when it comes to mediation? Where are the challenges? Most important is we are somewhere the mediators, not all, but the effectiveness of the training that is needed is not really percolating down, and therefore we need more training to have mediators who understand their role. It's very important for a mediator to realize that the mediator is not a judge, and that is where the problem comes. You see, in mediation, the ability, as has been very rightly spoken of earlier, the ability to cut down disputes by more than half exists if mediation is done properly. At the very threshold, conflict can be actually reduced or done away with completely if the right skill sets are employed in carrying out a mediation. Problem comes, we are coming from a mindset which is very adversarial, and we have someone sitting to resolve, adjudicate upon that conflict situation. That mindset is still continuing, and that is where the mindset has to be changed for the mediators, which will only come with constant training and retraining. And that is where institutional mediation takes becomes very important, because the focus that institutions have, like yours, have on ensuring quality mediators are available to carry out mediation is something that is a game changer. And that is where I feel we are going wrong right now, where we do have the mediation concept catching pace. We have very good mediators. I'm not saying we don't have, but what is going wrong is the understanding of the role. So the very mediators that we have who are extremely skilled, the challenge comes when they don't employ the certain skill sets that are needed in ensuring that they can bring an effective resolution to a conflict. Where do we go wrong? Sometimes what happens, see, mediation is not just, we say parties, but actually that's a wrong reference in my personal opinion. But then that is a reference. What happens is it's the whole human element that is coming into mediation. It's not just party A and party B. The whole human social experience is coming in when they are coming in to resolve the conflict, whether it is individual dispute, whether it is company dispute, because at the end of the day, companies are also represented by the individuals. The whole concept of mediation works on this, because it is a voluntary process. Two parties are coming together voluntarily to resolve their disputes by themselves, for themselves. If I may say so, very, very democratic process. They are doing it for themselves, by themselves, and will eventually arrive at their own resolution, whether it is going to be agreed or not agreed, whether the terms will be finalized or not finalized, that is their decision. The whole process is purely owned by them. Now, what happens in this? The mediator has to just gently work through this whole process of conflict so that they can come closer. In conciliation, it goes a step ahead. And we have part 3 of the Act, which Arbitration Act, we have, there are rules and regulations around conciliation, but mediation is very, very uncharted territory as far as rules and regulations are concerned at the moment, till we have an act in place. Now, what the mediator has to do is not employ threat and reward That is for the parties themselves to decide the reward and threat that comes out of the entire process, the proceedings of mediation. Mediator has to facilitate them to arrive at that sort of understanding. This is where the understanding sometimes is missing. And therefore, I have heard mediators say, we tell them, if you don't do this, this will happen. That is not a mediator's role. So what happens, even if under a sort of threat perception, a party may be willing to talk further, party will not resolve because it is not his voluntary decision. Yeah. So mediation will fail. So the idea is to, as Chitra rightly pointed out, talk, and give the parties their opportunity to be heard. Let them take out their angst. Let them move closer because now they have taken out their angst. They are not going to move closer because the mediator says, hey, you both sit together and talk. They will never come. Then you are setting that mediation for failure. Right? So there are skill sets that are needed, and those skill sets have to be, employed. And there are very good processes that have been put in place now, where, in fact, institutions like yours give very good infrastructure. You have good breakout rooms. The process is very clear. Opening session, then you meet them in person individually. Try and talk to them. Keep the confidentiality at the same time. Keep them invested in the entire proceedings. Let them understand that it is their proceeding. It is not you who's forcing them to come to an understanding. So these are the skill sets where I feel constant training and retraining. And I would say we need to now train even to the district level with those very skill sets that are employed globally. Because you have very good models now which are developed for mediation to be a success amongst various jurisdictions internationally. And I think the time is ripe. Even the smallest jurisdiction where mediation is adopted today as a result of our statutory provisions. For example, I would say even the Commercial Courts Act requires you to go through mediation prior to your being able to proceed further in the commercial court. Now, every matter is now coming to mediation, and as Ramakant sir pointed out, the awareness is so significant now, at least in a place like Hyderabad. I think this is the right time to train, constantly train and retrain even that smallest jurisdiction where a mediation, court-appointed mediation or otherwise may be taking place. And these skill sets have to be adopted. And I don't think anyone can do it better than an institution like IIMC, where the quality of mediators is very key, and great attention is given to that. Now, parties. The challenge that mediators see with respect to parties, expectations of parties. Parties are coming, when it is a court-appointed mediation or court-referred mediation, parties believe that it is an extended process of the litigation. That is not the case. They are not coming there to, sort of get their matter sorted in another forum. They are coming there for them to sort that matter in another forum. There's a fine difference, but that understanding is not there. And what is happening, while the fact that there is mediation is becoming, people are becoming aware of it, what really is mediation has still not been understood by that common man litigant on the road who they don't understand what mediation is. And therefore, I think sessions like these, which sort of inform general public about this court mediation, or rather mediation rather, what is mediation, I think is key. And I would say when we now talk about in our schools, when we teach and in our education system, when you have civics, we used to learn civics in our days. I don't know what there is now, but you have, there are sessions which talk about the judiciary, but nobody ever talks about mediation and conciliation. There is no conversation in any of these school books about alternate dispute resolution. It is very much here to stay, and it's going to be the way of future. And therefore, my Ramakant sir is here, and your institution is here. I think this is a conversation which should start. where children should also be exposed to when they talk about the judicial setup or the judiciary in India. What is litigation should also be understood, and how litigation can be effectively resolved should also be understood. And ADR as a process has to be, children have to be made aware of from the school days itself. That is the time that this change will happen. Otherwise, people don't understand what mediation is. So the biggest challenge that a mediator faces is when the party comes in with the expectation that, okay, court has sent us to you, you solve it. So the mediator is not there to solve it. Mediator is just bringing them together. And then it fails because the mediator is only working within certain parameters. And then there is again, they go back to the court. What has been gained out of it is that, there's just been another forum, and they have spent more time in coming to a solution. So this is a big issue. I feel awareness of mediation, what is mediation, what to expect from mediation has to be understood before the parties go into mediation. What also has to be understood is confidentiality. Confidentiality is key, and that has to be understood by both the mediator and the parties. Reference of these mediations cannot even be made to anybody in passing also. And this is why this is very important. Parties need to understand that your mediator is not going to be is a person who has no conflict and is going to be a person who will have nothing to do with the dispute going forward. All these things need to be understood, and therefore I think effective training, what you are doing is excellent. You're reaching out right now to industries. I am aware that you're reaching out to industry bodies. That is a wonderful thing to do, but also at a common man level, this conversation has to start that, when you're going to litigate, remember you have this option as well. So now, and coming to, how to tackle these issues, as I already mentioned, more awareness campaigns, more webinars like these. People need to understand institutional intervention is very important. And the importance of, so if I may sum it up, I think the courts should also consider involving institutes like yours, institutions like yours, because you are making sure that the right training is being given. So that the quality of training, the effectiveness of training of the mediators is very important. An unskilled mediator or a relatively, not reasonably skilled mediator will be counterproductive to the entire process. And then, of course, the campaign that you have to start and ensuring that there is enough literature out there for people to understand what mediation is. And when it comes to the process has to be strictly followed. There is a structure around mediation. What generally tends to happen is that it is done very loosely. It should not be done very loosely. It has to be crisp. It has to be cost effective. It has to be time effective. It has to, it has to be keeping all those principles in mind, which Ramakant sir was referring to, your principles of natural justice, making sure that, both parties have been given an opportunity to speak, both parties, and making sure that you have listened to them, because this is the human element. Somebody's ego may be ruffled. You never know. Just making sure that they are able to deal with their ego may bring a solution. Someone may be feeling that, I have not been given the due respect that I should have been given. I'm not being treated as if I belong to this organization. The relatedness to that organization may be threatened in an employee matter. So, these, if you listen to them, just simply listen to them and allow them to speak, and then bring them closer like that, putting all those skills in play, the mediator will be able to resolve. So these skill sets, the personal skill sets of the mediator, the professional skill sets of the mediator, the expectations of the parties, and hand-holding the parties through the process. I think the mediators initially must educate the parties about the process and expectations, something again I have seen lacking. I think these are the kind of challenges that I have seen in the implementation of mediation across various kind of cases. And I'm happy to answer any more questions, but Sunena, this was the observation that I wanted to bring on the table. Thank you.
Thank you. Thank you so much, ma'am. Thank you for your words of wisdom, your suggestions. They're very well structured. And like you rightly pointed out, I think listening skills, this correct amount of skill set that a mediator should have. More than anything else, a dispute, when you hear someone out and you listen to the party or a client, half of maybe your problems are solved there, not half, maybe that's one way step forward. And like you'd also mentioned that there should be more trainings and more awareness about mediation. That's the endeavor, ma'am. We hope that we are able to have some kind of success in reaching out to the common public and making them understand what the entire process is like.
Just one thing I missed, Sunena, that
Yes, ma'am.
there has to be good training for lawyers as well.
Yes,
As
ma'am.
Ramakant sir had mentioned, we need lawyers to be made aware of mediation process, and the fact that they wear a different hat as a lawyer in mediation and not the same hat as a lawyer in court needs to be very well understood by them.
Understood. Absolutely, ma'am. Thank you. Thank you so much, ma'am. So before we conclude the session, we'll just take up some questions from the participants. Ms. Simran Setia has a question. She asked if psychological element plays an important role in mediation, mainly on understanding the emotional and behavioral aspects of the parties. And as a student herself, how can she train herself for the mediation? And what are the kind of books that she would want to talk about? No, what are the, with some books on mediation does not talk about. So she wants to basically ask, what are the psychological elements? Does it play an important role in mediation? And she wants to give the panelists, if you all can give her suggestions on what are the books that she can read on areas and mediation, especially mediation. Perhaps if any of you all can answer.
Let me take this. Simran, you're absolutely right. Psychology plays a very important role when we encounter a situation of conflict and when we sit to try and resolve it. So it is important. Emotions are important. There is outrage, there is a sense of being wronged, there's hurt, there's anger, there could be humiliation, right? There could be resentment. So you're absolutely right. It is important to acknowledge that there is psychology involved in mediation, and that we as mediators, to take a leaf from what Purnima was speaking about, we need to know a little more in our trainings in mediation, and we do have some component of psychology. Not in great depth, but we do have it as a part of our initial or basic mediation training. In terms of books, I will, suggest a few through the IAMC, who will then reach it to you, the names of books. I'm not able to tell you off the top of my head. What can you do as a mediator? There are training institutes that provide training in mediation. Many organizations that provide training in mediation. And with your background as a psychologist, I think your training and your ability to help parties in the mediation process will be tremendous. So I do highly encourage you to look at training yourself in mediation.
Thank you, ma'am. We'll take another question. When is the most this is from Leenha. When is the most suitable time for the tribunal to suggest parties to mediate? And how should the tribunal do that? And should the tribunal do it? Purnima, ma'am, would you like to answer this question?
Sure. So it all depends, and every jurisdiction is different. In India, it could be at any stage during the litigation, depending on what kind of litigation it is. But so for example, if it's a commercial matter which is coming before the commercial courts, there is an act, and the act requires you to go through mediation mandatorily. So there is mandatory mediation. Then there could be a litigation where it's not mandatory, but then the court may believe that there is, value in going for mediation. In your jurisdiction, it may be slightly different. So I think it's better to understand from a statutory perspective. And if it's not from a statutory perspective, then, what is the practice in the court in that jurisdiction? And then accordingly, I think this question cannot have a one size fits all kind of answer. We'll have to look at it from a jurisdiction perspective.
Yes, ma'am. Thank you, ma'am. We have a last question. It's from Sabyasachi Chakrabarti. In the event during the process of mediation, mediator has come to know that there is a case of child abuse. Whether in this kind of a scenario, should he or she report to the prescribed authority or make it confidential?
Now, this is a very tricky question, and I would definitely like to hear Ramakant sir's views on this also, but I will just give my thoughts to begin with. See, the proceedings of mediation are completely confidential. However, we are also under the IPC, and the IPC requires anybody if there are certain sections which say that if someone has come to know about certain crime, then it is the responsibility of that person to report that crime as well. Though, of course, it's the individual who has to go and report. But if someone has come to know of something, there is a responsibility under the IPC to sort of bring it to the knowledge of the authorities. In such a situation, confidentiality vis-a-vis statutory responsibility, that is the point where I think you are trying to get at, and what would prevail. There would then have to be permission taken from the parties to be able to inform the authorities, and at least this the information has to be given to the party in question that you have come to know of this, and you are bound under whichever law to ensure that you have informed the requisite authority, and then go take permission and do it. And if permission is not given, then my suggestion would be, by way of abundant caution, statute prevails over everything else. You should do what the statute requires you to do. Ramakant sir, I would really like to hear your thoughts on this as well.
Yeah, I agree with what you have said, but at the same time, priority should be, confidentiality. And anyway, there are many judicial precedents, as you know, that they emphasize on confidentiality. But end of the day, statute prevails, and it varies from case to case. So with the aspect of confidentiality in the front of our mind, we have to tackle with the situation, depending on that specific matter that comes for consideration.
Chitra ma'am, any views?
There is a law called the POCSO Act, right? The Prevention of Commission of Sexual Offences Against Children Act. This law mandates that if there is any information that is received about child sexual abuse, the person will intimate the authorities. So there is a statutory mandate on mediators to inform, like it would apply to others as well, including doctors, to inform the authorities that there is sexual abuse. Now, both Mr. Reddy and Purnima have made a reference to, there are two policies, and there is, where do we find a balance between the two? There are some laws, including the mediation bill, which is there, which makes certain exceptions, including this, where the obligation of confidentiality does not apply. I think it's also important for us to see what is the information in the mediation that is expected to be kept confidential? The law as it stands doesn't cover all communication. It covers certain categories of communication, namely information relating to admissions, information relating to proposals made, any information that was created or produced only for the purpose of mediation. Right? So these are areas of information in mediation to which confidentiality and possibly privilege attaches. So first we need to see what it is that is protected by confidentiality, and we need to see if there is a law that imposes on any person, a responsibility to report. And if we don't have guidance from these two, I think we need to look at what it is that we are looking to protect through confidentiality, and what it is that is contesting this area or this policy that stipulates confidentiality, and what should give way to what. Right, and I think in cases like this, it's fairly clear that the child's interests are paramount. Fortunately, we have the law supporting, or guiding us on what we need to do. Thank you.
Absolutely, ma'am. When it comes to child, it's very well regulated. And recently, I had an occasion to appear in a POSCO court. There, we can't the robes, the coat, the gown, the choice of words, it's entirely regulated. We have to go there normally dressed and be friendly, but we'll be in a friendly atmosphere. The judge also will be in civil dress, and even the children who are there connected with the POSCO case, it's an entirely different atmosphere. It's not like a lawyer or something like that. It's like a school or some place where everyone known to each other meeting. But what happens there is, discussion about the case, and that's all. So it's very well regulated. So like I said, it varies from case to case. Confidentiality is depending on the case. So it was a totally different setup there from a regular court.
I think the important thing is also to look out for precedents as more and more mediation is happening, and more such issues will come up, where conflicts will happen with the various other statutes that prevail. We will find judicial precedents coming up, which will clarify such points. So I would always advise that we should look out for, people should look out for precedents whenever there is a tricky issue regarding, what will prevail over what.
Absolutely, ma'am. Do we have any other questions? One question from a law student. Good afternoon to all the panelists. And we wanted to ask how we can make a career as a mediator after law school, and what are the skills a mediator must possess. I think Purnima ma'am has already covered the skills for a mediator, but how to make a career in mediation as a mediator, I think that can be answered.
Chitra, would you like to take that?
Okay, no, I thought Mr. Reddy was answering, so I held back. May I, Mr. Reddy?
Yeah.
Okay. You can get trained as a mediator through mediation institutions. You could also ask apply to be an intern in these institutions, where you know how the process of mediation is administered, and with the permission of parties to be able to shadow the mediator and sit in the mediation, subject to your very serious responsibility of maintaining confidentiality with respect to what you've seen and participated in. All of this gives you a sense of what the mediation process is, and then get trained as a mediator. And I'd urge and exhort you to do that, because I think both Mr. Reddy and Purnima made a reference to this, how you are as a lawyer who believes or who is convinced that parties should also take steps towards mediating their disputes. This will definitely sort of inform and guide you as a lawyer in helping your clients resolve their dispute. So not just to act as a mediator, but even in your responsibility, your role as a lawyer, it makes a big difference if you're trained in mediation. So I would urge you very much to please be trained in mediation.
Thank you so much, ma'am. Thank you to all the panelists here today. We've now come to the end of our discussion. And on behalf of IAMC Hyderabad, I once again thank all of you and Mr. Man Singh, Governing Council Secretary, AIADR Secretariat, and the participants for joining us today. And I believe that it has been an insightful and thought-provoking session for all. And I request everyone to join us in another webinar that we'll be organizing soon. Thank you so much.